Am I audible?
Yep, you're audible.
Okay. Um, I'll take POIs through chat. You can alternatively raise your hand on Zoom. Okay. Mm-hmm. Okay. I'll start my speech in three, two, and one. This precedence will spur the world into chaos. It will roll back investments into green energy and technology, the cooperations and agreements that already existed between governments, built on trust and built on the ability for them to not blame it on sole companies and sole countries, and worsens the average person's access to energy, which is terrible on a vulnerable scale. The only thing I'd like to clarify and set up is what would our world look like under the comparative? We'd prefer direct intentionality instead, which is broadly the idea that because diffusion is difficult to access and assess, it is just global responsibility over specific faults rather than faulting specific countries over the issue of climate change and how we ought to resolve that and whether or not we ought to pay these people back. First argument. Why does this ruling become ineffective and in fact worsens not only Germany's situation, but also the general battle towards climate change? Under the first framing, and I want to note this argument is split into two framings. Firstly, if you presume that the jurisprudence is only applicable within Germany, why is this bad on a broad scale? Firstly, what we'd explain is that if it's restricted to the precedents of Germany and it only applies there, the problem is that all of the issues that relate with things like investment, things like the access to technology or the access to green energy, are explicitly only restricted towards Germany, insofar as people can go to Germany, blame their companies, blame foreign FDI, happens in these instances, and therefore cause things like Germany not being able to access things like FDI or just investments into green technology. Why is this broadly bad in isolation? The first is because it only applies in the context of Germany. This isolates their energy crisis. And if you believe that's difficult for people right now to access clean energy, to access accessible energy because of maybe the war on Ukraine and different external factors, it's just worse for the average person on the ground, the average German citizen. But secondly, it's that companies domestically now scramble to move abroad. They have to create multinational relocations, move outside of the borders of Germany at the point of which they are in fear of being held accountable, especially because it's isolated in these instances. Broadly, this is bad for two reasons. One, it's bad for foreign investment into Germany, which I want to note is probably one of the strongest perpetrators of things like green technology and green energy. But secondly, that it's bad for local business within the area insofar as you get overall less investment, but also that local divestments themselves move out to different countries because of fear of these things. Second framing of context. Even if you believed it wasn't only restricted to Germany and it expanded towards the world and people could hold international companies and countries accountable, why is this even worse? The first is because you can't control what happens. And I want to note this uses the same frame that comes from opening government of needing a big win, of sensationalizing this event, of coalescing a lot of more opt-in, not only within NGOs, but with other external actors that you couldn't possibly control. There's two broad reasons why this is bad. The first is an assessment of the best case that happens on government. Their best case is this farmer gets 17,000, but sets worse precedent for perverse actors to shut down competitors, i.e., people like Shell competing against Petron for like things like gasoline and whatnot, locking out other international foreign businesses at the point of which you have the FDI to hold them accountable because they were inevitably able to create more diffusion and create more climate change worse on scale. But secondly, it's hard because it's based on past emissions. And this is an important nuance. You can punish forefront leaders of green energy investment, who I want to note used to be coal dependent, but now transitioned into things like green energy. Think of the most prominent investors of things like green tech right now because of imminent fear that they might lose business in the long term. It's oil companies, it's electrification, it's automobiles that are forced and subsidized by the government to transition towards green technology. The problem is you are never sure that these people can never be held accountable, and that by effect means you can retrospectively hold these people who are leading things like green investment accountable for things that they've done in the past. This is just terrible for a broad host of reasons. Now they're more scared to do these things in the future. Now they're more scared to divest in green technology. It doesn't seem worth it to them to invest in these things because they can be held accountable anyways, regardless of how much they change and no matter how much partnerships they currently make with the government. But secondly, this is counterintuitive to a lot of investor interests. It's the uncertainty of the growth of their own individual stock, which even permeates green energy, which I want to note itself utilizes mining, itself utilizes coal and other pollutative resources to build these things, which not only weakens general investment in currently pollutative industries, but also transitionary industries that still rely on things like coal, still relies on things like mining cobalt, which are pollutative and can be held accountable to that extent. What does this mean? Companies might turn green for a variety of reasons, absent this litigation that even exists, right? Maybe it's the long term saleability of their company. Maybe it's things like them wanting to transition into different markets and access these things. But the problem is you lose all of these incentives at the point of which it's now more risky for them. You create fear or the general idea that it's not worth it for you to do these things because any incentive for you to divest can be just rolled back at the point of which these things are retrospective and it can be held back for stuff that happened in the past. Before I go into my second argument, I'll take POI if there's any from closing. Opening.
Yeah, sorry. If your activities are now
Also.
so different from what you did in the past, why can't you just close down your company and incorporate a new one that's not responsible for the old stuff? This seems very easy.
I mean, like, why would you close a multi-billion-dollar company? Very clearly, these companies wouldn't want to do that. I'm not sure why it's in their incentive to do so. It's obviously in their incentive to rather transition and make sure that they're able to do these things peacefully and maximize profits. They wouldn't do these things as like safely as you want to claim. Second argument: why does status quo fine, and why does it get better in the future on just a micro scale for individuals? The first thing I want to explain is why we're able to prop up stronger cooperation between governments, between countries, and between companies. What we explained firstly is the comparative on government looks like a blame game. Who is the one who is causing most climate change right now? Whose diffusion right now can be assessed to the most objective scale, I guess, to be able to impact the most majority of people in the most despondent countries. This is a problem because now it becomes countries going against one another, companies going against one another, individual governments going against their own local domestic like companies at the point of which they want to prop up this ideal and veneer of morality and principled ideals. But secondly, you don't lose the trust from government and between countries under our side in the comparative because now you aren't afraid of people holding you accountable for things that happened in the past. But thirdly, it's the framing of this. You frame it as a collective effort of the world to try and resolve rather than villainizing foreign countries and companies at that point of which it's true. Maybe the principle is important. The problem is the principle could never resolve the pragmatic issues that exist right now. Secondly, that farmers usually, and perhaps the people who are most actually affected by things like climate change, won't actually sue, right? The framing for us is clear. It's likely venture capital, private equity, vulture funds with self interests, which is why farmers with too little capital, who lose to first mover advantage, or who lose to access to info and legal ability, are not the ones who benefit from a vast majority of these things, but rather rich companies that only serve to grow bigger and bigger and widen the wealth disparity and monopolies that already exist. If you don't want the world to tumble into chaos, if you want climate change to actually be resolved, it only happens under our side when you oppose.
Yellow for the great speech, and now invite DPM to continue the case for opening argument. Here.
Okay, so POIs in chat, please. All right. Okay. We'll record my speech. Starting in 3, 2, 1. The first thing I will do is take out a lot of the illogical and simply unempirical claims that come from opening opposition because it takes a lot of logical leaps for you to believe them at no point Zen provides at all. The first thing they say is very strange. They say they prefer direct intentionality instead as the basis for legal litigation. One, this is just overturning every other jurisdiction in the world that by default in Germany and in common law in every country in the world recognizes negligence and strict liability as valid basis for legal responsibility anyways. OO is literally asking you to believe a world that doesn't exist for their benefit of not harming the companies which, by the way, we've proven have harmed people. Secondly, they say strict intentionality. This helps the polluters. There's no deterrence, no engagement with our case. They just say, well, what about the people that have all the money? Maybe they'll have less money. I guess that's a good thing. Like, I'm unclear as to why you should believe intentionality. This is counter to reality on their side. The second thing they say is companies will now scramble to move abroad, like from Germany, because of the fear they will be accountable. One, OO doesn't understand international law. The courts are increasingly willing to hear transnational claims regardless if the companies go from one place to the other and emissions follow the emitters regardless. So it's not likely that they're going to cause a bunch of capital flight to somewhere else that they don't explain. Likely it's the case it just causes a flat deterrence effect and black effect, for example, for them to increase their behavior towards being good behavior in this example. But secondly, if they do this, then this also forces the green transition, which prevents the abuse of domestic companies, for example, of the global south or other places, which is the good thing that they say doesn't happen on our side. So we've proven as to why it does happen. The third thing they say, very weirdly, this ruling will scare companies away from investing in green technology. One, look at what optically this does. If they invest in green investment after this ruling, this makes companies which would, if they were perceived as the rest of the other companies, be less likely to be perceived as a company of bad faith and a company instead of proactive good faith to restore what they've done in the past, and they're less likely to have these cases be filed against them and to have these kinds of things be heard in the first place. So it actually forces the green investment and transition opposition. I don't understand this argument. Secondly, even if this is true, this also accelerates the transition. If they are afraid of legal exposure, that's an incentive for them to invest more. I really don't get the logic of your case. Thirdly, even if it causes hesitation to enter into areas, for example, note, often there's a political, economic incentive for them to enter into areas anyways. They're already transitioning also into green energy. If you force the transition faster, it's better than if a lot of people are lagged in the past, for example, in less efficient models, etc. That is a short-term price to pay for a long-term efficiency and less bad effects for people on the ground, less people getting harmed, for example. The last thing they explain is this very weird second argument. This ruling pits countries against each other. The first thing I want to note is that this case targets corporate polluters, and specifically in the instance where we can have an attributable amount scientifically to what they have done. If you cannot elaborate your claim, this doesn't make sense, because obviously we have to have some people accountable, guys. It just assumes no one should be accountable. Clearly there has been actual harm done. Secondly, even if some national tensions arise, this is better than the current system. The current system is no one pays, but the global south suffers 90% of climate-related deaths. If you prefer to have someone pay, if they prefer to have someone be investigated, we prefer the corporations and the companies of the West, for example, at the point where we can attribute it scientifically with this precedent and with this jurisprudence that they have done this. Perhaps you want collective responsibility on your side. This is collective responsibility because we're acknowledging as the world that there are certain people we can attribute specifically to having done harm. At this point, then, there's literal no logical sense in their case at this point. What was our case? Firstly, our case was that it was principally necessary and justified at the point where, one, global warming is a global issue and a harm is created regardless. Even if you didn't know, we have the ability to partially claim that you have, and thus you bear responsibility for that. Cannot say we don't have basis, we have basis. Literally, we've proved causation. Why has client science improved to this extent? Firstly, there's many records of these things. Now we can have historical tracking and data. Number two, there's more of these people do this. There's more investigation of the science behind this, which improves into the causation aspect of it more. Thirdly, there's more jurisprudence and acceptance of this as a metric, which is more people feel as if it's just, for example, to prosecute to this extent. The second reason why we give principally is that it's allowed people a sense of restoration and restitution. Just gives the analysis of maybe it could harm the profit downline. Guys, people are already transitioning into green energy regardless on either side in this debate. But the harm is that regardless if they transition or not, they can just get away with past emissions without any form of restoration or restitution. We prevent that barrier first by saying the companies that we can attribute and the ones that operate in bad faith, we allow this as a precedent to actually climate litigate them, versus the comparative on their side, where often 90% of climate litigation cases are thrown out because of no causation. Second argument then. We prove that we strengthen climate litigation. And climate litigation is important. We explain that we, one, expand jurisprudence for a legal basis, but number two, expand the credibility of legal climate litigation so that companies can see that's a legitimate deterrence. The importance of this is threefold. Firstly, if they want to talk about profits being harmed, companies being dissuaded, note, companies are already being dissuaded in this world. They are already told they have to transition away from green. The problem is that they don't pay people, especially the biggest ones, can't afford to pay people. They have not proven as to why they can't afford to pay people in that transition. Secondly, paying people actually makes the adoption of the green tech far better, because now it assumes that people have moved past the harms of oil, for example, in the past. They are now able to restore these things, for example, and provide green tech for the developing countries, etc., as well as restitution of these through legal like compensation and fees, for example. So this also allows people to move on more charitably and transition into the future. But thirdly, at minimum, it allows victims to be heard. And this is the most important part of this debate. Even if we do not believe they are directly accountable, this debate ought to be decided on the fact that they are somewhat accountable. That is what the basis of the jurisprudence is and the legal ruling is. OO and CO have to believe they are not accountable at all to deny an average farmer the ability to sue a person at the point where ice caps, for example, all of these typhoons, for example, have harmed their livelihoods, have harmed their children, have harmed their future. They deny access to this kind of restitution and justice and representation on their side, which is just a terrible thing to do. Because even if we don't have any principled pragmatic impact in this debate, it's this. These people are denied the voice to be heard and the ability, for example, to make impact in that world, and that is terrible on their side of the house. We have science, we have basis, and we can prove this in our world. Op has to say no one is accountable, and that is terrible.
Thank you, DPM. Diallo.
Hello, am I seen and heard?
Yep, you are.
I actually think opening government is a bit confused. So the first thing I'll do in this speech is chat a bit about the legality of all of this. To note, our case is not reliant on direct intentionality. Let's talk about the case on their counterfactual of direct causality. They firstly say that global warming is a global issue, therefore somebody needs to be held accountable. If I fart, I am indirectly contributing to the methane emissions, which means that I would theoretically, under their frame, be legally liable for some random person who dies of a greenhouse emission or something of the sort. But we don't, because we understand that direct causality, even by the things that they say, are so difficult and arbitrary to measure that you could extrapolate it to on different lengths that make it far harder to be able to determine the actual bounds of the case. So it's either the case gets thrown out because it's too legally impermissible to be run in the first place, or it's the case that it's too irrational. I want to note that while they say that some form of reparation is important, the moral continuity of the action as they concede must be set first, as is what is currently being practiced in every single legal state within the world. We recognize this principle in court, for example, where we allow different cases and different trials for different people because we submit to the fact that we should not conflate these actions with another, and doing it so would be paramount to putting an innocent person in jail. The complementarity here and the principle is that we cannot be sure of a person's individual actions with regard to how they caused it, which is important because if it is true that this society is consequentialist, they have not proven the sufficient claim as to the consequences of this action. This person and this company didn't even live and didn't even operate in Peru. And so within the specific context of this case, it is legally impermissible and there's no grounds by which this should happen. But even when we are dealing with vulnerable victims, I note we always suspend forcing individuals to pay things like child support or pay things like reparations until we are able to, for 100% sure, determine that causality. So even by their own moral metric, they fail. But I want to play ball. They say that this is about hearing people, even though we've conclusively explained that the principle at this point, at their point, is incredibly contradictory and just doesn't make sense within any legal system in the world. So I want to talk about climate and how these people are affected. If it is true that climate change is a global issue, then the utmost importance for these individuals is ensuring where climate change gets a better ending at the end of the day. How do we solve climate change? And this is the core of the argument that we give you coming from Zen. It is not magic, as opening government states, because Zen does a great job of illustrating that the initial cost of green energy and transitioning is both climate intensive and reliant on companies who have previously engaged in fossil fuels and have permanent incentives to want to transition into green in the first place. And the reason why is very simple, because fossil fuels will probably run out in 50 to 100 years, which are why there are massive natural incentives, even by Saudi Arabia, which is the biggest exporter of oil, for example, to want to invest in these companies regardless, which illustrates to you that there's already a trajectory towards solving this crisis in the first place and preventing the emission of greenhouse gases through chat, dude. What I'd explain is that this is the clearest way by which you're able to solve climate change. OG says this bolsters green companies, and therefore that makes it easier for them to gain funding. But I want you to think about this. Closing government can't just bake their cake and eat it too and say you incorporate a new company. Because other than the fact that this submits to the fact that it's not important to give reparation and ignore the people that are asking you for money in the first place, this also just legally doesn't make sense why the country would allow you to do this, given how this is a legal loophole and likely subject to the very special of antitrust laws. But what I'd explain is that green companies, being incredibly climate intensive in their own right, at the end of the bell curve with regard to other companies like restaurants or even fabric companies, right, are still going to be at the better end of it. And Zen posits to you a very, very pernicious incentives by vulture funds and rich individuals who want to take advantage of this legal precedence, i.e., large individuals who just want to make a quick buck and make sure that the money that they sue, because theoretically, it's a global issue. Every single person would have legal jurisdiction if you do believe that this is a global issue, which already indicates that even in their best case, where this is a humanitarian issue that affects the entirety of the world, it's still unclear why they have any better thing, which is either the case that you massively chill the investment into green energy, or at the very least, into energy in the first place, which means that a just transition cannot be facilitated by these countries, which means that the political will for voting in better green policies and politicians will also not exist, which leads to a cascading effect of these things getting worse in the first place. Or it's the case that this exclusively happens in Germany. The chilling effect happens regardless because they understand that the fear of the international courts adopting this perhaps may happen, which either leads to massive pullouts from individual countries because they can now be legally pursued by every single person in the world by virtue of this, but it's also the case that it becomes impossible to fund any sort of energy reserves insofar as the cost and the risk is far too high. What we explain is that they ruin the world either by making food far too expensive for individuals or because they absolutely destroy the industries that were supposed to solve us and take us out of this crisis in the first place. Which means that for this farmer, it is more typhoons in the future and more that are begging and begging for their lives in the future, whereas we provide a clear pathway by which this is able to be fixed. Before I go on, closing. Opening.
So the legal proportionality is the basis. You have to read the info slide, Sam. It's not lucky it causes a massive chilling effect for ExxonMobil if there's a farmer that has the chance to be heard. You can't explain that somehow magically this chills all green investment.
Legal precedence exists regardless of the size of the case. So if I, as a massive vulture fund, now decide to sue another company for $100 million, under that same legal precedence, it is still able to be upheld with the same lawyers. This chilling effect exists because the risk of individual companies and vulture funds who want to take advantage of that precedence exists as well. But importantly, it's about competition and them wanting to try and sue each other by means of being able to do this, which means that there are massive pernicious incentives for competing rivals to be able to undertake and ruin the world in which you say. This is important because even if you don't believe all of the legal analysis we've given you already, the fact is their claim that it's important that these people's voices are heard is reliant on a prerequisite assumption that these people are important and that their plight and suffering due to climate change is a morally important value. This argument explains why that value infinitely multiplies on their side because they completely destroy the balance for how these things happen in the first place. Like, we don't just massively switch into green energy in the first place, but rather we employ a just transition that allows for people to gradually be set towards these instances in order to ensure that there's no inflationary effect that ensures that people starve. So people starve under their side. Climate change will never get solved, and this legal precedent will ensure that no amount will happen in the future. Even in the middle impact, you at least ensure that it becomes far slower in the comparative, which means that more people die in the interim. For all these reasons, very proud to stand on OO.
Thank you, DLO. MG.
Perfect. I'll take POIs verbally, probably from CO. As a law student, this debate makes me kind of angry because I don't think either front half team understands how precedent works. Like, both teams just claim that now a precedent exists and this is suddenly enforceable in every single country in the world. If you just gut check this, I think this is untrue. Everyone knows international law is kind of ineffective and every country has different laws. Obviously, if something happens in another country on the other side of the world, it's unclear how that applies to my specific legal situation. I'm going to do two things for you then on closing government. Firstly, I'm going going to explain why winning this case actually does create legal precedent beyond Germany that's likely to be binding, maybe not globally, but at least within the EU, which is substantially more than we had before. And secondly, I'm going to talk about why the fact that this is retrospective and it punishes you for your global net emissions actually creates an incentive for companies to invest in green technology and in other environmental programs in a much better way than they do under the status quo and to a much larger extent. So getting into the first extension. So firstly, I think it's important that this lawsuit is taking place in Germany despite the fact that the plaintiff comes from Peru. This means that they are able to take the lawsuit to a developed country that actually has a pretty functional court system and the capacity to enforce this judgment against the company. Because the problem under the status quo isn't that you can't win a lawsuit, it's that you just cannot enforce this. Like, Ecuador has constitutional rights that protect the environment, and indigenous people there have successfully sued huge oil companies all the time. The problem is that because those companies are headquartered outside of the country, outside of the continent, and they don't really care what the judge in Ecuador says, the people that win those lawsuits are unable to get any kind of meaningful compensation, and they cannot enforce the judgment, and nothing changes in the company's behavior. Germany, unlike Ecuador, is a large country that does have headquarters of a lot of multinational corporations. Like, most of the big emitting companies in Europe are headquartered in Germany. Things like Mercedes-Benz, like all the big car producers that have presumably contributed quite a lot to emissions. This means that when you sue them on their home turf, and this is the government that they pay taxes to, the government is able to actually enforce the judgment and ensure that the compensation gets paid out to the people suing. And this is good for a few reasons. Firstly, because it means you actually do get the money at the end of the day, not just a paper saying that you're entitled to it if you can collect it. But secondly, because the fact that they have to pay it out changes their incentive calculus going forward in a way it doesn't if you sue in a different way. And the fact that you're now able to successfully win a lawsuit in Germany not only enables this now, it means that in future, people from developing countries have the option to sue large corporations in Germany specifically, despite the fact that they don't have any ties to that country, which is really, really good because it means, again, they're more likely to be able to get an enforceable judgment. I think even if countries don't have headquarters in a place like Germany, they are much more likely to have substantial business operations there, to not want to piss off the German government because this is quite a large economy, and therefore to actually pay the money that's being ordered against them, whereas this is not the case if you lose a lawsuit in Senegal, you can probably just ignore that. So that's already a win. Secondly, though, we think that Germany is quite unique because it's in the European Union, and there's a pretty substantial amount of legal integration within the countries in the EU. The goal is for the EU to eventually become a little bit more homogenous, to have more cohesive legal systems, and so there's pressure on courts to generally harmonize law over time. I think this is a reason why the German precedent is likely to be pretty significantly considered in other court decisions from other countries within Europe. Secondly, though, I think that all the stuff that OO tells you about how Germany doesn't want to get fucked over and have all these big companies divest from Germany is a pretty big incentive for Germany as a country to lobby within things like the EU Council or the Council of Europe to ensure that other countries also follow this precedent and impose similar disadvantages on any large corporations based on their country. Because if any country in Europe is now going to make you pay for your net emissions over time, then there's no incentive for companies to move their headquarters away from Germany. So Germany is likely to put pressure on places like France to adopt similar legislation or to follow this precedent in their courts, or make a press release saying they're going to do this, which again means I think you're likely to get contagion within Europe. I think they're likely to succeed when they put pressure on these kinds of things for a few reasons. Firstly, Germany is just the biggest economy in Europe. They've got a lot of money. They can probably, as a result, they've got pretty substantial political sway within most of the European institutions. But secondly, I think Europe is already generally a relatively progressive place. You already have quite a lot of countries with pretty strict environmental legislation, places like Norway, Sweden. I think when Germany proposes this, they're likely to get buy-in from those other countries that will opt in to enforcing this type of judgment in future. I think then we've proven to you that you're likely to get pretty substantial climate legislation within all of the EU enforcing similar lawsuits and judgments against companies like this, where the plaintiffs don't necessarily have to come from within the EU. This is already a huge win for climate legislation. Secondly, though, on this divestment claim, I actually am going to give you a few reasons why it's actually quite hard to divest. Firstly, the EU is a huge market. I think it's hard to divest from Germany as a country. It's even harder to divest from all of Europe. This is half the rich world. These are enormous numbers of consumers. Obviously, it's better to just comply with their legislation. This is why iPhone has finally given in and changed their charger. I think you're likely to see the same thing with other companies. Secondly, though, it's just like hard to move all your employees and factories to another place. Like you have to uproot like hundreds of people that have families and probably don't want to move, and it's hard to find skilled workers abroad. I think it's probably like a lot harder than you claim to just divest. Finally, though, I think developing countries are likely to now prioritize European investors because they know they're able to hold them accountable to a higher degree, and so there's some comparative advantage that comes from being in Europe. Okay, finally, though, on why it's important that this is retrospective, I think it creates an incentive for companies to focus on reducing their overall emissions rather than on like other performative environmental policies that maybe get them better PR but are actually less effective from a like climate point of view, right? Note that under the status quo, a lot of these green policies are quite performative, so you like, you know, donate some money to save the pandas or something, but this isn't actually particularly important to the ecosystem and doesn't do a lot to actually offset the harms of climate change. I think when there's now a credible threat that you are likely to be punished for not being able, like for the net amount of emissions you've produced, you have strong incentives, firstly, to reduce your emissions in future, but secondly, to redirect some of the funding that you're currently putting towards fluffy stuff like saving the pandas towards instead offsetting your previous emissions, so doing things like carbon capture and storage, or again, doing things to prevent future emissions or at least offset the ones that you're doing now. And the crucial thing here is that the incentive that is created isn't just a one-time thing where like as soon as you've made this investment, you get a PR boost and then it sort of maxes out. This is an incentive that scales depending on the amount of money you put into it because you get a corresponding like, you know, lower future settlement you have to pay out in lawsuits and lower likelihood of future lawsuits, which means that it actually incentivizes you to continue investing beyond a certain amount of minimum. I think finally, though, you now get investment not just from companies that are currently emitting, but from previous emitters. We would actually like them to put money into offsetting their past emissions. On this basis, I think it's a clear CG ballot.
The MG for the great speech, and now the MO.
All right, cool. Making sure that I'm audible. POIs in chat, please.
Yep, you are.
Awesome. All right, 3, 2, 1. This has been a debate of every single team thus far massively and thoroughly overstating their impact without a sufficient mechanization for why they would get such a dramatic change. Opening government pushes a burden which is frankly extremist. They say that opposition bench has to defend that these companies are not responsible for environmental degradation. No, we do not. All we have to do is say that this decision coming out in the way that proposition would rather it come out would lead to bad outcomes for environmental justice and environmental protections. We absolutely do not have to have a debate on whether or not they are culpable of the crimes that they are being accused of. Secondly, proposition bench wants to say that this is going to lead to improvements for the environment. And this is a claim which is frankly unbelievable to me. Why? Because the information slide tells us quite clearly that the payout we're discussing is 17,000 euros. I don't know how much 17,000 euros is going to be able to help a small village in Peru in their ability to make sure that their community does not suffer to floods. I think that the labor costs, the material costs, and all of the other types of costs associated with entirely redesigning and terraforming the land that you are on in the interests of making sure that you are not able to actually suffer from floods is so much more than the amount of money that you're being given in this regard that you are not going to actually lead to any sort of change. Secondly, if they say that this is going to lead to companies wanting to change their behavior, when we are talking about multi-billion dollar energy production companies, 17,000 euros is not a rounding error. It's a rounding error of a rounding error. It is an amount of money that is so fundamentally insignificant to these companies that they would never notice again in their life that they had paid this money, and it makes no impact whatsoever on their decision making because they deal in budgets 10 to 100 to 1,000 times larger in scale, meaning that impact about how this is going to be a fine that all of a sudden means that they start going throughout European Parliament and making sure that there's competitive legal structures throughout all of Europe so that no company behaves this way. Why? They would be spending so much more money in legal fees to actually try to lobby for such an outcome that this would be fundamentally unjustifiable. There's no reason to think that they're going to not invest in green technology as a result of this, because again, when you're investing in green technology, it is a multi-billion dollar investment to try to make tens of billions, if not hundreds of billions of dollars by being a first mover. So again, there's no tipping point in this regard. And if a proposition wants to say, oh, but Ethan, this is additive. Think of all of the lawsuits that can come up. Guys, you would have to have thousands of lawsuits on a regular basis against the same company for that to be reasonable. And if panel, you think that that's kind of a bit ridiculous to assume that individuals in the global south or even globally are going to be able to do, because one, they don't have the legal knowledge to be able to do this. Two, law firms aren't necessarily all that interested in taking on such small potatoes types of cases for the amount of money and time that you're going to have to be taking on and the amount of like high-powered lawyers you're possibly going to have to be against. And because, you know, you might not be able to determine that your particular country was in any way meaningfully harmed from the outcomes done by a particular company, I'm not sure that this is going to lead to the types of change that they suggest that is going to actually do. So I'm just not sure that you can credibly address most teams within the round as a result. However, what we want to suggest in closing opposition is straightforward, that this lawsuit being resulted in the way that Proposition wants leads to worse environmental policy being advocated for on the margins. Why is this the case? The first reason is because this is a fundamentally reactive policy, right? People have lived and died, people have gotten sick, and they're not going to be able to get money to recoup that type of cost. Why? Because when you are trying to calculate the amount of environmental pollution a company has done in the past 450 years, it is going to be a microscopic percentage that applies to each individual community, meaning that the scale of harm that exists from having been living in a polluted environment for 400 years cannot equate to the amount of money that it is going to be able to meet up for, meaning that at no point are you actually being given restitution. But the problem here becomes straightforward, right? Why would companies take the initiative to engage in not green technology, but green initiatives to clean up their own act and to engage in some level of their own PR that tries to, you know, clean up where they work and just implement green policies in their own firm, when they can pay a microscopic percentage to a country that happened to have been affected and say that, well, they paid the money when they were asked and they're accepting full responsibility, knowing that the people who are harmed aren't actually getting the money. What you end up doing is you individualize the response to climate change because you say, well, communities who are harmed should just nut up and sue these firms if they want to be able to create change, because companies are going to say it doesn't fall on us anymore if these countries actually want to be able to take action. I think, however, because of the reasons that I explained previously, you actually get a lot less instances of people being able to sue these firms, a lot less instances of payouts being particularly significant, but you lose out on the interest that these firms had on engaging in green actions. The second thing that I would say that ends up happening as a result of this is that you also are not giving money to the correct actors. Guys, if we read the info slide again, you are giving money to an individual farmer. What obligation or responsibility does he have to this community? Does he have to the environment around? We have no reason to think that this is going to lead to benefits to these individualized communities while offloading the responsibility that companies had onto the public. But here's where this gets particularly worse, right? Currently, the narrative when it comes to implementing aggressive environmental policy is clear. It is that these companies are, by and large, hugely responsible for the ongoing crises of today, that as a result, strong and immediate action that is taken in regards to policy is what needs to be done in order to adequately address the climate crisis. However, the problems that exist in status quo is that people are afraid of such radical actions because they are afraid that it is going to risk their job and lead to other sorts of long-term economic harms, that they don't necessarily feel comfortable doing this, but they're willing to accept it because they are aware of how big the problem is, and we're able to identify the handful of firms that are actually responsible for this, and we feel that we are doing targeted attacks on the most responsible parties. The problem that exists under their side is you create a counter-narrative which in a sense diffuses responsibility from firms. We take major international energy producing companies and say that they're responsible for 0.5% of the situation. This leads to two outcomes when it becomes a common tactic, as Proposition Bent wants it to do. The first is you end up creating a cycle of despair. People go, well, if the biggest companies in the world are only worth 0.7% of global emissions, what is the point of doing anything when we are all already inevitably screwed and there's very little that is available to us? You make people less wanting to engage in political action because they feel completely hopeless. The second thing is that these people who now have legitimate economic worries about the fact that they might lose their job if we engage aggressively against climate change now feel validated in their concerns because they look at the companies that they work for and say, oh, but they're only responsible for 0.3%. Why bother doing this? And as a result, when they could have been in support of these policies, they now go against it, which harms the movement. Proud to oppose.
Thank the MO for the great speech. Gov, we have to close out the Gov bench of the House.
Yeah, just 1 second. Okay. All right. 3, 2, 1. Panel, I think 17,000 euros is far more than anything CO tries to claim. CO tells you that it's just not a lot of money, that this is not going to be something that companies are going to be afraid of. It's not actually going to be a significant return. Firstly, I don't think this actually engages with what NAS tells you about the stuff that a lot of these companies probably would rather avoid these lawsuits simply because they would rather just spend this money on things like green tech. I'll get more into that. But secondly, this is only one person suing you that was harmed by these emissions. This means that right now you are paying 17,000 euros. Alternatively, you could be paying millions and billions of dollars because the emissions that you have done have harmed many, many people. So this means that a lot of the people who are going to be harmed could come in droves and want to sue you at the same time. Companies typically want to avoid this. Companies don't want to have to deal with these kinds of lawsuits, which is why this one particular lawsuit is probably a good thing, so that in the future, these companies invest in technologies or do things that are going to be like, or do things that are going to be like more climate friendly than what CO actually tries to aim. The second thing about like dispersing responsibility is like, I think that generally when you are probably just still going to be responsible for the things that you've done. So the emissions that you've caused, you're still going to need to pay the price for those for that particular issue. Also, 17,000 euros probably goes a long way in places like Peru. So each individual that asks for 17,000 euros who is harmed by this is probably going to be significant as type form of compensation for the kinds of farmers that are likely going to be asking for this compensation. Usually it's going to be farmers in like the third world. And as Anais told you, it's like when you have these farmers or when you have these individuals who are harmed by this kind of compensation, or sorry, when you're harmed by these kinds of emissions, it means that they have an opportunity to, because the precedent has now been set, they can sue a German company, they can sue like this kind of company, and they can make lots of money from it. So companies would typically then be deterred from that. A few more things on what Anais told you. Firstly, Anais told you that it's like companies are more likely to then reduce emissions in the future. This incentivizes you to do things like invest in green technology. The reason you do this is because you want to avoid these lawsuits that you're going to do, firstly, but then also it's going to be increasingly better for you because not only are you going to comply with the existing policies in the EU, you're going to then effectively reduce emissions in the future by investing in green energy anyway, and so because of this, you're likely to actually reduce emissions regardless. Okay, a few pieces of refutation on opening government. Firstly, I think that on opening opposition. Firstly, I think that what Anais tells you, basically that like basically that it does, or at least the front half in general, basically that this doesn't go beyond what Germany, this doesn't go beyond international law. Like the idea is that at the very minimum, if you're able to sue like a German company, if you're able to get a lawsuit to be passed for you for like a Western-based company, it means that you're going to get a lot more, at the very minimum, climate legislation within Europe. You're at least going to get a lot more leverage for people who are like, you're going to then just allow like people in the global south to have a lot more leverage over these companies who are intrinsically harmed by like these climate emissions, right? And also just that when you're able to do this, like it allows you to enforce these kinds of issues a lot better than you could do otherwise. Okay, why is it then likely that these companies are then just going to want to invest in green technology anyway? Firstly, I think in the status quo, a lot of companies, because of the green transition, already are trying to invest in green technology. But I think when you face this threat, and as as OO tells you that this creates fear, and they talk about this chilling effect, the problem here is that this is probably a good thing. This urgency means that these companies are going to be far more willing to invest in this green technology. They're going to take it far seriously. They're going to do things like R&D towards developing technology that's going to be like more climate friendly. And because of this, you're not only you're reducing climate emissions, but B, you're also going to reduce the amount of lawsuits that you're going to get for these companies. Anyway, the third thing is because it optically looks good for these companies to invest in these kinds of things. So, for example, if you're a company that is like losing this lawsuit to a farmer, it optically doesn't look good for you because you probably care about like investor incentives and that kind of shit. And because if you continue to lose, if you continue to have like millions and millions of people who are affected by these climate emissions, like target you, this looks bad for your investors as well. This looks bad for your company, knowing that if your investors feel like your company is going to like have to pay billions of dollars out of like billions of dollars to like compensate for these lawsuits, it's probably very difficult to like for it probably looks bad than just optically, right? And so I think that generally most of these companies are going to want to are going to be incentivized to move forward with like investing more in green energy. Finally, then I think what NAS tells you about specifically about the difficulty in moving abroad, like the stuff that OO tells you that okay, these companies will just up and get away. A few more reasons for why this is probably not the case. NAS tells you that it's hard to move abroad, but also it's really difficult to completely establish new networks or new networks. You now have to deal with different kinds of competition within different countries. So you can't just move your company from like Europe all the way to the United States, and then now you have to deal with a different set of rules, a different set of laws, which is already incredibly difficult. But also because generally, in many of these Western countries, you probably want to move your country's headquarters in like a more developed country anyway, and because there's generally more progressive laws towards climate change in those areas, you're going to be dealing with the same kinds of issues, irrespectively, like symmetrically. So it's not going to actually bring that much of a change. So it's probably easier for you, considering the cost that you face to move your country and the cost that you face in terms of compensation. Your company is more likely to then just stay in Germany, and you're probably going to, and it's not going to be nearly as bad as OO likes to claim there. With that said, proud to propose.
Can the GovWeb op web to close the debate?
Am I audible? I just had to switch technology halfway through the
Yeah,
round.
you're audible.
Give me 1 second to organize myself. Okay. 3, 2, 1. I'm going to go through the government bench and prove why their cases fall, but then additionally do some differentiation as to why we win over our opening half. First off, on opening government, their main claim is that like proximity ought not to be the barrier, and there are practical harms that have happened. I think that if you read the info slide, this is about threatening of harm. So I think that it falls in the fact that there is no actual harms that have been established in the info slide. But then additionally more so is that the idea that they say that there's a material benefit because the community gets money. I think this is wrong, and Ethan flanks this because it is one Peruvian farmer who's receiving $17,000, and as Ethan tells you, is that there's no incentive established by the government bench as to why this person would has the ability or the capacity or even the incentive to actually reinvest this into his neighborhood and to prevent these. But then additionally, it's unclear how $17,000 is able to possibly mitigate these harms, fix these harms, or prevent these harms from happening, because it's just there's no analysis on this kind of regard. But then additionally, they say that they are afraid of legal exposure, companies and that kind of stuff, and they will transition. But the thing is that if they're able to handle, if they're able to refutation to this specifically, if they can be held responsible things that have happened in the past, what does transitioning actually change? Because the past simply still exists even when you transition. $17,000 is less than this transition as well for multi-million-dollar companies. As Ethan says, this is a rounding error of a rounding error that they would simply not see existing. And so the thing is that it does not they're more likely to be able to burden this as opposed to the money that it would take to possibly invest in this kind of regard in regards to opening government case. But then additionally, we flag that even if they are legal responsible in this lawsuit, we all that matters is that this will lead to innate harms, and we don't have to have a debate about culpability in this regard. But then additionally, when it comes to closing government is saying that you don't want to play the fine, so you will change. But we say that these suits are calculating your percentage of harm over the last 450 years. So it's not going to be a high number, so you won't pay much. And many victims won't have the capacity to follow the suits because it's hard to bring up in an international case. Also, this means that companies say, actually, if you think it's our fault, and then sue us about it, rather than actually take initiative, because they know that they are able to burden the cost of this like rounding error of like $17,000, which closing government says that $17,000 is a lot, but we say the village is afraid of being flooded. That is nowhere near enough money to make up for the damages of flooding in an area. So their principal victory means nothing by contrast of our impacts. But additionally, for like our case specifically, continuing the CG case. Like CG says, this will get Germany to impose more green regulations. Like we ask why, because there's no need to make business marginally more difficult when CG agrees that these companies don't want to leave Germany. So in this regard, it doesn't really make any sense. But we like specifically say that in our case, the tipping point is that people who are cautiously supportive of climate policy now feel like they're unjustly targeted because they start to see that their company is only responsible for less than 0.5% or 0.4% to be specific. But then additionally on carbon, like 4% of carbon, so they feel like they're giving up too much in this regard. And people will see that companies like BP, which is maybe responsible for possibly the 1% of all emissions, and feel like their actions like mean nothing in this kind of regard. So specifically when it comes to our case, you lose a substantial amount of political will because it's hard to justify aggressive action against these large companies when you're also saying that they are simply responsible for less for 0.5% of damages in this regard. But like specifically is that government bench never proves as to why like this person specifically is the one giving this money, because it gives money to actors that don't have the capacity or the never established incentive to mitigate the environmental harm and does not give them the money to actually do so. But then additionally, like I said, like they don't pay out enough that may be necessary, and it removes political will. In this regard, we have 3 very clear impacts in this kind of thing, so that we are able to outweigh the rest of the round. But in terms of weighing over our front half here with opening opposition, I think that we beat OO arguments simply about on green tech, because companies in this kind of specifically on opening opposition case about green tech, because companies want to invest in green tech because they want to be the first in the market and they're adopted by a lot of customers and this kind of stuff. There's still profit and innovation, and you still want to choose to invest if this means that you're sued for something else. Because in that kind of regard. So specifically with that case, but more specifically, in that kind of sense. So in summary in this kind of thing, the government bench and all does not prove why this person specifically needs this kind of thing. Because we also say that companies will happily let themselves be sued by Peruvian farmers because they can engage in a lot of these stall tactics. I think we forget about the ability that companies have when it comes to these kind of things. They have the capacity and the incentive because they don't want they don't necessarily want to engage with a lot of these kind of things. Even if we want to say that this is amount of money, they can engage with a lot of stall tactics and just hope they run out of money or sue or get tired and stop it, so they will make sure that they don't pay out in this kind of regard. They have the capacity to operate in these stall tactics, and they don't actually get any of the benefits that government wants to claim in this kind of thing. But specifically just to flag is that
Yeah, so the key is this is $17,000 per capita. There are 7 billion people that have been affected by this harm. If even 100 of them get together and sue you and they're each entitled to 17,000, that's a fuck ton of money. Your average class action lawsuit only gives you $4 back. I think this is a pretty strong disincentive.
Based on the interpretation of the way that everyone's the round has been operating, we've all been operating under the understanding that but also even if this is a lot of money, even if it is to what Anais is saying, is that even if $2 million is still not necessarily the largest amount of money for these companies, because they have so much money in this kind of regard. They have so much money able to do these kind of things. We can and additionally, if they don't want to pay this out because it is that much money, they can delay forever. As prior to I stated earlier, companies have a lot of stall tactics. So even if it is this amount of money that we say that could possibly reap this kind of benefit, in the long term, if you are able to establish this, you don't actually get this benefit because companies are able to delay this kind of process forever. And if poor people necessarily need to bring this to sue, which is not going to happen. As Ethan says, people in these kind of situations corporations don't necessarily have the resources and don't necessarily have the institutional legal knowledge in order to bring these kind of cases to this regard. And so they don't actually get those kind of benefits. Insofar that because they're able to delay these kind of tactics, which is very possible because they have not only the incentive but the capacity, the fact is that the harms on their side severely outweigh, which is specifically about the fact that you remove political will to actually get long-term long-term impacts because you were simply diluting the issue. You were sorry, I'm out of time.
Thank the op for a great speech, and everyone for what was a great round. Just to remind everyone, this is a silent round, so you guys will not be getting an OA, but you can reach out to me after the break for feedback.
Ross, thanks for the round, everybody.
Thanks for the round.
Thanks.
Everyone.